As for the Wildlife Conservation Act, it was amended in 2007. It now requires the indigenous people to obtain permission from the government for their hunting activities. Details of the implementation law still need to be worked out by Forest Bureau and the Council of Indigenous People. However, the two parties are yet to agree on certain specifics, pending further discussions.
By virtue of the Indigenous Peoples Basic Law, the authority in charge of the Basic Law shall amend, stipulate or repeal relevant laws within 3 years after the law takes effect. Meanwhile, the Wildlife Conservation Act states that the indigenous people must seek approval from the government for hunting, slaughtering, or the use of wildlife for their traditional events. It also states that the government body must consult with the CIP to establish the application procedure for hunting details. However, because the two parties have different views on traditional culture and hunting methods, they have not been able to draft the amendment to the Wildlife Conservation Act.
In
September 2008, the CIP sent us a list of details which we reviewed on October 16 and made our suggestions. We asked the CIP they give their confirmation within a month. Perhaps the details involve the cultures of the different indigenous groups and are complicated. To date, we have not received a reply from the CIP. The Council of Agriculture has reservations on some cultural traditions mentioned in our proposal. They question if certain activities could also be considered as traditions or just ceremonies. Those traditional events in question were suggested by the indigenous communities. We are still in negotiations over the differences in opinions.
The CIP says the CEO has suggested a clause which requires hunters to use traditional hunting methods and tools. But whether traps and certain devices are considered traditional, it still needs further discussions with indigenous people. In order to expedite the legislative process, the CEO has suggested the indigenous groups that have reached a consensus to propose the specifics first, but CIP says it will cause unfairness.
The law should apply to all. There is no priority group. We as the administrative unit cannot choose any priority group because all groups are equal. So there is no such issue as to which group has priority.
Zhang says the CIP has spent a lot of time coordinating the issue in order to help all related parties resolve their differences. TITV Weekly.